descendants of the 1878 Sulu Sultan have successfully secured the $14.92 billion award ruling in Spain against Malaysian government. On the 2nd of February, 2023, Minister in the Prime Minister's Department, Law and Institutional Reform, Datuk Azalina Othman said the Malaysian government has just received official confirmation that the constitutional appeal filed by the descendants of the 1878 Sultan of Sulu on the 5th of November, 2021 against the annulment of Mr. Stampa's appointment as arbitrator in the so-called Sulu dispute has been rejected. Describing it as another significant victory for Malaysia against the descendants, Azalina said the Spanish court's annulment of Stampa's appointment as arbitrator is final and reaffirms Malaysia's position on the arbitration case. The descendants sought to initiate conversations with Malaysian government to settle their differences on the 1878 contract of lease agreement and the 1903 confirmatory deed on the 28th of April, 2017, and on the 2nd of July, 2018. The descendants received no response from the Malaysian government to these legitimate requests. The descendants informed the Malaysian government about their intention to commence a commercial arbitration in 2017 and initially sought $32.2 billion in compensation. However, the Malaysian government still ignored them. On the 8th of December, 2017, given that there was a British component in the 1878 contract of lease agreement, the descendants' lawyers approached the UK Foreign Commonwealth and Development Office for guidance as to whether the UK was a suitable forum. This was turned down. On the 31st of January, 2018, the descendants' lawyers went to High Court of Justice of Madrid, HCJM, to request for arbitration. On the 29th of March, 2019, HCJM heard the descendants' case and assigned Gonzalo Stampa as the sole arbitrator. In April 2019, Spanish Ministry of Foreign Affairs served Malaysian government with formal legal notice about the case, but the Malaysian government ignored it. In July 2019, the arbitration began without Malaysia's participation. On the 19th of September, 2019, the Malaysian government wrote to the descendants' lawyer, Paul H. Cohen, and to the arbitrator, offering to resume the 1878 and 1903 contract of lease agreement and to settle the matter without arbitration. However, the descendants refused it. On the 5th of October, 2019, the Malaysian government appointed and sent the international law firm, Herbert Smith Freehills, to attend a procedural hearing of the case in Madrid. On the 9th of March, 2021, Malaysia made a claim to the Madrid High Court of Defencelessness. In June 2021, Malaysia sought to hold the arbitration proceedings, citing that it had not been served proper notice. Madrid's Superior Court allowed Malaysia's application. However, Stampa argued in his award statement that the courts did not have jurisdiction over arbitration, and moved the case to France to deliver the award, actions that Malaysia says were unlawful. On the 29th of June, 2021, the HCJM issued a decision that annulled the judicial appointment of Stampa to act as an arbitrator on grounds that Malaysia was not properly informed about the case and was thus defenseless. Azalina said, as a result of this decision, the HCJM retroactively invalidated Stampa's appointment and nullified all his actions as a purported arbitrator, including the alleged preliminary award he had rendered in Madrid. The decision of the HCJM was final, binding and directly enforceable, and could only be subject to an extraordinary constitutional appeal before the Spanish Constitutional Court if exceptional circumstances were met. This decision confirms the legal position that Malaysia has asserted since the dispute began, effectively ending the claimant's judicial strategy in Spain. As a result of the annulment of Stampa's judicial appointment in Spain, he lacked the authority to act as an arbitrator and should have immediately put an end to the purported arbitration proceedings. Malaysia has subsequently taken legal steps to invalidate Stampa's two purported awards. The Spanish courts have now further confirmed the annulment of Stampa's unlawful appointment as an arbitrator, finding that he never had any legal authority to act in that capacity or to issue any awards, and that therefore, they are null and void. The Spanish Constitutional Court decision vindicates the government's policy to vigorously defend Malaysia in every court and forum, exercising all its powers, rights and resources to ensure that Malaysia's interests and sovereignty are protected at all times. Paul Cohen, a lawyer for the Descendants, said, "The minister claims that Malaysia has achieved an annulment of the arbitration case in Spain. The opposite is the case." On the 1st of December, 2022, the Superior Court of Justice of Madrid, the Spanish court that appointed Dr. Stampa, made a unanimous ruling that not only was the arbitration process in the Sulu case still valid and extant, but that it had never been annulled by that court, or any other court, nor by any action by Malaysia's lawyers. Moreover, the ruling stated categorically that Malaysian lawyers failed to pursue the appropriate action necessary to try to annul the arbitration awards. The accompanying judgment described the Malaysian legal actions as procedural fraud. In spite of repeated requests by Malaysia for the court to declare the arbitration as invalid, annulled or unlawful, the court judgment categorically refused to accede to those requests, and closed the matter. Dr. Stampa's award on jurisdiction is therefore final and binding in Spain. We look forward to the Malaysian explanation. This apparent triumph deeply misrepresented the state of play. A good save by the goalie in a football match in the last 10 minutes of a match when you are 5 goals down is worthy of a cheer. It doesn't constitute a win. On the 28th of February, 2023, Azalina begged European jurisdictions handling a claim by descendants of an 1878 Filipino Sultanate of Sulu to respect the Malaysia's purported sovereignty over Sabah. Despite the stay, a French judge in December 2022 granted the descendants' request to seize 3 Malaysian government properties in Paris to settle a debt of €2.3 million or $2.46 million that they said was owed to them, according to court documents shared by the descendants' lawyers. Malaysia had been ordered to pay the descendants the sum under a preliminary arbitration award granted to them in Spain, which was not bound by the stay in France, the descendants' lawyers said. On the 6th of March, 2023, French bailiffs attempted to evaluate the 3 properties in preparation of a sale, the descendants' lawyers said. The proceeds of the sale would go to the descendants. On the 8th of March, 2023, Azalina said Malaysia intends to summon the descendants to appear before the same court regarding the seizure order on 3 properties in Paris. A Sultanate of Sulu official branded on the 13th of March, 2023 as disinformation the statement by Malaysia that the Sultanate's descendants will be summoned by Malaysia to appear before the same court regarding the seizure order on 3 properties in Paris. The Sultanate of Sulu official said, "It's just propaganda to make the Malaysian people believe that they are addressing the arbitration. During the arbitration proceedings only our lawyers were present without any Malaysian lawyers." On the 14th of March, 2023, the Paris Court of Appeal maintains the stay order obtained by Malaysia on the 12th of July, 2022. The stay that seems to comfort the Malaysian government temporarily delays local enforcement in one country, said Cohen. Malaysia was able to secure a stay from a Luxembourg court, but Sultanate lawyers are expected to appeal the ruling. With some exceptions, such as diplomatic premises, any Malaysian government-owned asset within nations party to the UN Convention is eligible for enforcing the award, said Elizabeth Mason, another lawyer for the Descendants. The Sultanate of Sulu official said, the Sultanate's lawyers have expanded their move to enforce the $14.92 billion arbitration award against Malaysian assets in the Netherlands and all over the world. Cohen said, this filing in the Netherlands will soon be followed by other enforcement actions of varying types in the multiple jurisdictions. This may include the immediate, direct attachment of specific Malaysian assets in the Netherlands and elsewhere. The petition did not mention specific assets, but some of the Malaysian state-owned companies in the Netherlands include Petronas and palm oil producer Sine Darby Plantations.